tell us about like what you've been going through here in response to just, you know, for a long time now you've been dealing with the industry, and what does this resemble in your fight against it?
Well, my point, it's about the pollution, the air, our way of life. Before industry was here, this is all farm community. You know, it's about the people, it's not just me. This is just a way to shut the people up of the county and of the state. And I just don't think it's right. And when you can recontaminate the ground, and your ex-lawyers are and go, oh yeah, you're okay, you're good to talk. And then you bring a lawsuit 5 years later. Yeah, come on. Something's not right.
What do you make of Cabot's argument that you can't repollute?
Well, that's wrong when you sit there and look at the test results that show it's worse. And then you have 6 brand new water contaminations. From what I understand, some say 3. I heard 6, so I'm not sure which it is. But when you have brand new water contamination that wasn't there before, across the street, you know, that's repollution. So, you know, argument goes again, you've got new contamination that wasn't there before. That was only from not drilling, that was just from fracking. So does fracking cause groundwater contamination? You figure that one out.
What's your response to the $5 million punitive damage figure?
Do I look like I got $5 million? Oh, come on.
That's off the table now. They said that, right?
No, actually, they didn't say it was off the table. What they said, it was improper to put it in the pleading the way they did, and that has to be stricken from the pleadings. That still doesn't say that they're not going to try to go after $5 million against somebody who is functionally at this point judgment proof, because that's just intimidation and nothing more. There was a lot of testimony today about the fact that Cabot is substantially offering this basically as a marketing exercise because they want to have their version of the story out into the media, specifically when they offered the pleadings to the Washington Post before they served them, which is not exactly something that's going to weigh in the court, but that tells you what their motive is.
When you jumped on this 2 weeks ago, is this David versus Goliath to you?
In a word, yes.
I mean, what is this? I mean, what do you think Cabot's motive was in going to the courthouse in the first place against your client, Mr. Kemble? Was it to chill dissent? Was it to discourage other people from speaking out? I mean, how do you see it?
A lot of it is Goliath acting out in a way that you would expect Goliath to behave, which is, you little David, you keep your place in line, and that's as far as it goes. And that's kind of the way we do these things. These contracts are written up to keep everybody quiet, but the problem that you get into here is that the court's now going to have to decide who breached, when did they breach, and who has what obligations. But if Cabot wanted this to quietly go away, this was definitely not the right way to do it.
Well, what I'm saying is, do you think this is bigger than Mr. Kemble? Do you think
Oh, God, yes.
they're trying to use Mr. Kemble to send a broader message? And if so, what is that message, you think?
The message is that we, as the oil company, need you to not be raising this stuff publicly. That just lay low, stay quiet.
Ray, back in April when that federal lawsuit was filed, they're saying you were evil, malicious. Was that your intent?
No, I just turned around and spoke the truth onto it with the test results that was given us by the federal government and the state. You know, the state came up, DEP's the one that turned around and said we're contaminated. DEP's the one that put a 9-mile moratorium in effect, endemic, which is still into effect to this day. They're not allowed to drill or frack, endemic. So it's still there. Ask DEP why there is still a moratorium endemic.
How come then withdraw that federal lawsuit 2 months later or so?
Well, again, you know, this reason I have attorneys. Okay, I don't know the law. I'm not a lawyer. Okay, here it is. He has all the documentations. He has everything I have. Here it is. He's the one that proceeded with the case. You know, again, here's my lawyer. Okay, I'm not a lawyer. So I mean, I don't know how else to try to say it.
Were you uncomfortable up there? It seemed like kind of taking the stand, going even up to the defendant's table.
No, you know, they wanted a specific answer. I couldn't give a specific answer because, you know, I don't pay attention to the dates. You know, I got other people that watch that stuff and know about it. Like I said, you know, Craig, Bill, they were doing it. They have the dates.
No, I'm just saying in general, you know, actually having to be up in the courtroom and defend in a
because, you know, just remember, David took out Goliath. I'm David.
What are you wearing today? What's that?
What? It's a back brace.
What happened to your back?
I broke my back. slipped on the ice and broke in 3 places.
What's happening across the street from you now?
Well, let's see. We just brought DEP in. They retested the water, found out the water is contaminated still. Due to the reworking of Costello 2 or whatever they're redoing up there, and it's within the 2,500 feet and under the Act 13 law, yeah, they were supposed to turn around and notify us and retest the water, which is never done. DEP said they didn't have to, but if you look at the Act 13 laws, anything within 2,500 feet of, you know, reworking the pad, any type of work to the pad whatsoever, you're supposed to do the test results, and that was never done.
Baseline test.
So I turned around and called DEP up, and under the Act 13 law, and they came up within 24 hours, retested the water, which we got the results back, which I'm not going to say what they are, but, you know, again, the water's contaminated. They suggested that the, you know, the well be vented, you know, due to the methane coming out, and I sent a registered letter back to them, thanking them for what they've done and everything else onto, but in respect to that, under the consent orders that was done between DEP and Cabot Oil and Gas, states that they were supposed to put a vent on the well. I go back to those orders, that you ordered them to do it, it was never done, so
In 2010.
it forced them to turn around and do their job.
Can you describe what your water is like today?
The best way we describe the water is take 2 asses of a skunk, every household chemical, and some industrial chemicals, throw it in a blender, put it on puree, dump it out, and take a whiff. That's what the water smells like. Why it smells like that, we don't know. Even ATSDR and everything else, they like to know why it smells like that. We still don't have these results back. They're still under study and everything else of these. Again, once we have those studies, you know, they'll be given to my attorney to, you know, take care of this. Again, everything we talk about, you know, is everything that has been, these are test results from DEP. These are test results from ATSDR, EPA, DEP. These are all federal testing that's been done, showing the contamination of the water wells.
How many of the wells on your street have been contaminated?
Roughly, I'm going to say maybe 19, maybe more, now with the new contamination there, so you probably got more.
Have those people settled with Cabot?
No, my neighbor across the street, Ken Morcom, is now trying to work some type of settlement out with them on the contamination. He's one of the new 6 people that were contaminated. So he's trying to work out a deal for them to buy them out.
Because with these gag orders they got on everybody, what's the problem?
They don't want us to talk. Shut up, go away, you know, go behind the corner, you
How
know.
many people have got gag orders?
Well, everybody from the original lawsuit was gagged. I refused to sign it. I immediately took that order. I gave it to my new attorney at the time, which was Spears Law Firm. He read it. He rewrote it. The attorney of Tate Kunkel signed it. Again, we'll bring that out in court.
Mr. Raiders, your first order of business, there was a default judgment.
Yes.
Cabot obtained a default judgment against Mr. Kemble,
Yes.
correct? Because of he didn't respond in a sufficient within the time specified. Is that the reason?
Yes. Our civil procedure rules basically say that you have to make certain responses in certain time frames, otherwise the other party can ask for default.
Okay, so your first order of business is to get the judge to reopen that, or to set it aside, to reopen the case, essentially.
Yes.
Spell your last name.
Raiders.
First name?
Rich.
Have any of these
We like the Giants.
non-disclosure agreements ever been made public?
Yes.
Cabot has
They-
hundreds of them, don't they?
It depends on the case. I don't know the specifics of which ones are public and which ones aren't.
What did I like to say? You know, I did respond to them. I wrote a letter to Judge Legg. You know, I told him I need more time to get counsel. All right. Well, it wasn't done the proper way. Well, I didn't know the proper way. You know, I wrote a letter and we brought it up and it was, you know, submitted to the court. After a few weeks later, we found out there was no response to this or anything else. And so Bill came up to check to see what was going on. And in the process, he found out, you know, they were saying it wasn't filled right or whatever. So Greg turned around, called the court, and talked to Judge Legg's I guess, secretary, and well, you have to do it this way, blah 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 blah, which I don't know, how to do a motion or any of this stuff, and that's when they started, Craig and Bill started writing it up, and with the motion and stuff, and that's how it started getting filed. But I mean, I did answer it immediately, but nobody recognized it because I didn't do it.
So assuming you get the case, the judgment set aside, that's when you start arguing the anti-slap issues, correct?
Among other things, yes.
Thank you.
Is there anything else you'd like to add?
I'm good. You good?
Right now, I'm good.
Well, actually, I'm curious. You said you've called so many lawyers. Why did you want to take this case?
I represent a lot of landowners in various interesting matters. There's a case over in Huntington County involving an eminent domain action where there's been a lot of activism that I represent those landowners. And that's part of my practice, is to represent landowners who are fighting against people who are taking their property. So that's a major part of what I do.
Thank you.
Okay. At the same time, although he does have the right to issue a different order. So stay tuned.
How do you feel that he handled his role today?
The judge? Judge did his job.
I agree. It just,
Judge's job is to ask a lot of questions.
And that's who we're defending.
You did that.
Do you have any idea when? I love you too, honey. Yeah. Yeah.
So all the people will be here. Keep getting bigger and bigger and bigger.
All these liberals.
Has to come out. Yeah, that happened.
That was for all right.
And that's also for Ray?
Well, that's for everybody.
Oh.
If they want to do damages, then they have to come up with a argument in front of trial as to why they deserve that money. So we're far from knowing any of that.
So right now the $5 million is dropped?
$5 million is dropped. They're not allowed to allege such things. And everybody conceded that. The judge conceded it. Both parties conceded it.
and that's done. That
That's
can't
done.
be.
Well, let's see what happens. If they can prove $5 million in damages at trial, then that's their privilege. Until then, we don't know.
Are you a little relieved today, Ray?
So there's a plus part about it. So like I said, we'll take it day by day and we'll see what happens. Eventually I will go, but I'm not going quietly. You think I'd even be here?
True enough. True statement.
People have the right to talk.